I've been reading all night. All right, good morning, ladies and gentlemen. Just a few announcements before we get started. This is arraignment court, so we are here only for arraignments. Nothing else. Not here to determine guilt or innocence. If that's what you guys are looking for. That's not today. We have a busy docket today. Everything is being live streamed, so feel free to live stream if you want. Today is open court. Do whatever you want to do. Just don't make noise. Are we all good? Are we ready?
Okay.
Everybody ready? Who's up first?
Number 34, Montez Merriweather.
Judge, do you want me at the podium or do you want me at the sidebar?
You can be wherever you want.
Yes, sir. Thank you.
Good morning, counsel.
Good morning, Judge.
State your name for the record.
Alex Deardorff on behalf of Mr. Merriweather.
On behalf of the prosecution.
Keep going, Your Honor.
All right. The oath waiting.
I believe so, sir.
Oh, yeah, he's fine. I told him anybody can stream if they want to. Anybody can stream. Yeah, it's being streamed by, I don't know how many cameras now, so one more is not going to hurt. On these next 6 defendants, do we have the prosecuting witnesses here?
We do not, Your Honor.
Were they notified to be here?
They were.
They were given an opportunity to participate if they wanted to under Murphy's Law?
I've been in direct communication with their attorney. They have attorneys retained. They know about today's date, which was not here.
All right, is the signing officer here?
Yes, sir.
Okay, is he going to speak today?
No, sir.
I do have his 527 and his bond preference, correct?
Yes, sir.
Okay,
This is case number B 25-04011-A, Montez Merriweather. You've been indicted with 3 counts felonious assault, 3 counts assault, and 2 counts aggravated riot. Have you received a copy of your indictment?
He has, Your Honor, the plea is not guilty as to all counts.
question I have for you at this point, has he been indicted federally on other charges?
Yes, Your Honor, on 1 weapons under disability that they decided to indict as of yesterday.
So are they going to pick him up or
I
let
haven't
us handle our
received,
case first?
I haven't received information as this happened late yesterday, but I still would like to address bond after consulting with another attorney that may be assisting with that. It would still be our expectation to ask for a release as that case is pending. Not to get too much into that, but there are other occupants in the vehicle that was involved with, so he may have a defense as to both.
Mr. Prosecutor, as the bond,
All right, as the bond remains the same, I think it's reasonable.
what is the current bond?
I believe on Mr. Merriweather, it is $500,000 with EMD should that bond be posted. The reason I think the bond is adequate, Your Honor, when these cases first came in through Room A, it was a very new situation. All the investigation had not been completed. And I'm going to repeat myself quite a bit here this morning.
Please do.
The grand jury, after hearing the probable cause of these cases, added several charges to each and every one of these defendants. For example, Mr. Merriweather came into Room A with a felonious assault and 1 count of assault. Through their investigation and our presentation to the grand jury, he's now been indicted on 3 counts of felonious assault, 3 misdemeanor assaults, and 2 counts of aggravated riot. I think the bond where it's set is appropriate. I would not ask to reduce the bond. I know he is a holder from the federal court system. And my great concern is if he posts a bond here, he would be taken into federal custody. On a gun charge in federal cases, Your Honor is aware there's substantial mandatory time. It's a very real possibility that if he was taken into federal custody, we would never get Mr. Merriweather back into Hamilton County for a good number of years. I believe the bond in this particular case is sufficient and adequate, and I ask that you keep it the same.
A few questions for you. I know that the initial charges were brought about by a couple of videos on TikTok and Facebook. Does the state have actually more videos that they're going to produce?
We do, Your Honor. Several videos have been received by Cincinnati Police Department. We have reviewed those. It is our plan within the next upcoming days, once discovery is filed by the numerous defense counsel, we will get them all copies of all videos. With their permission, I'll put together a court sequence that makes all sense. We'll turn that over appropriately. There are particular, I can think of 2 videos that have never been seen as far as I know through social media.
Are those videos from individuals or from stationary cameras?
Stationary cameras.
All right, they were in the area.
Yes, sir.
Okay. Did the alleged victims participate in the grand jury process?
Yes, sir. I've
They were
personally been in contact with them. They are interested in going forward with these cases.
Are they local? Do they have local addresses?
Some do and some don't.
All right, but they will be here for the
Yes, sir.
trial.
Oh, yes, sir, 100%.
Rumors are spreading that they are out of the country. That's not true.
No, sir. So just so everyone is aware, there was one person who was present. She is a citizen of Estonia, I believe. She is not any of the alleged victims here. Shortly after this event, she made the decision to go back home. She was here for either a vacation or a short visit, but she is not a party to this matter whatsoever.
So all of the victims are here.
Yes, sir.
Local, ready to proceed.
And I've contacted them personally, and they are interested in going forward.
All right, thank you. Yes, ma'am.
As to bond, Your Honor, thank you. Judge, I will speak only, I'm going to be very careful about my representations based on what I have reviewed. Obviously, at this phase of the proceedings, it's arraignment. I have done numerous investigations and numerous interviews to make sure that everything I represent as far as our defense is as accurate as it can be. And I say that because this case, every time there's coverage of it, the prosecutor's statements about it, the comments used are the group, the 7, the riot. And I think as far as setting bond, it is very important for courts to look at an individual's conduct as it relates to what an appropriate bond is.
I agree.
And I say that because most of the videos shown where some of the conduct about stomping, kicking heads, things like that, as far as what would probably constitutes the felonious assault, was not done by Mr. Merriweather. As I indicated, probably 20 videos that I've watched numerous times, and I brought them to court to make sure my representations were correct, indicate him involved in a fight, a fist fight, and there's no debate about that. And the video shows when some of the individuals go on the ground, Mr. Merriweather walks away. And I do have footage of that with me today. And so I say all that, what we're here for, bond. We're not here to try the case. However, the bond of $500,000 is an incredibly high bond for that conduct specifically. And I know what he's indicted for, but what his conduct was, it will be our defense, is more consistent with an assault, maybe at worst an aggravated assault. So to come with objectivity before this court, I reviewed bonds set in 585 for similar offenses. All of them were $10,000 or less, and I have case names to present. And I say that also because the only charge of felonious assault that did not involve a firearm was a $50,000 bond at 10%. And that involved last week an individual that stabbed his father with a butcher knife, and that was $50,000 at 10. So now we're back to my client involved in fist fighting with a $500,000 bond. And we are asking this court to set a bond at $75,000 at 10%, much higher than the bonds that were set on other comparable felonious assaults. In addition to that, Your Honor, he's a father of 5, 3 of whom are biracial, because that's become a crux of this case, and I think that that's important to note. I've interviewed witnesses that will testify at a hearing and at trial that racial slurs were thrown against him and his family on this date. And so that comes back to, while we're not here to try the case, we're here to set a bond on him using fists. There is no allegation that he had a weapon. There's no video I've received that contact was made by a kick. And so I asked this court to set that bond because it's reasonable with the conduct in other cases in this courthouse. And if the media was not here and if the attention on this case was not here, I genuinely believe that a $75,000 bond for a fistfight would be absolutely reasonable to almost any jurist in this courthouse.
Except for the fact that he was out on bond when he committed this, or allegedly committed this offense, correct?
And, Your Honor,
And you know how I am, if you're out
I
on
agree
bond
with
and
that,
you commit
sir.
another offense.
I agree, sir.
Right.
And so I think with that offense, while we're not here to try it, I
Right.
did a careful job of reviewing that case prior to today's hearing to represent to this court that involved a motor vehicle stop where other occupants were in the car.
Right.
And a firearm was found. He was the only person under disability. So it is important for sure. which is why I think 75,000 higher than the $10,000 bonds that I've seen across the board out of this courtroom. We also would ask for EMD strict lockdown. That accomplishes a lot of the other goals of the purposes of setting bond, which I won't reiterate for the court. But I say all of that because I do think his conduct, I want to take this opportunity to make very clear for everyone that is listening that his conduct, we do not believe rose to the level of felonious assault, and we ask that this court set the bond appropriately. Thank you.
Mr. Guinan.
I want to make the record very clear so everyone can listen. Throughout the short duration of this case, several defense counsels said that racial epithets were thrown at these people. That was 1 minute and 47 seconds into this brutal beatdown. Were the words said? Yes. Were they inappropriate? Absolutely. But these poor people were being assaulted, stomped, WWE style elbow drops onto pavement. One woman was knocked out to the point that her head hit the pavement. We could be a homicide. For counsel to say that he is only responsible for misdemeanor assault is beyond the pale. And against all the facts, she has not seen all the videos. Nobody has except myself and the officers involved here. Again, he was out on a bond for a weapons charge when he chose to get involved in this brutal beatdown. And again, so the word goes out and the word is clear. The horrible racial epithet was 1 minute and 47 seconds of these people being beaten, stomped, knocked unconscious. I don't want there to be any type of misunderstanding about this. This fight was started by these defendants. They followed them on the corner. They told them, quote, "You are at the wrong party. Get off this corner." And that's where these assaults started. I think the bond is appropriate. This man has already out on a felony charge. He has now been indicted federally, and I ask him to keep the bond the same.
Tell me about his prior record. I didn't ask about that.
As indicated, he's got a pending weapon under disability, CCW.
How many prior felony convictions?
Let me see here, I'm sorry. Of course, I don't have that other thing.
And Judge, while he's looking, and I understand that, I know the court is very patient, this will not be a back and forth.
No, take your time.
But I just want to make very clear as well, that again, the prosecutor's comments as it relates to other individuals' conduct, WWE stomping, we agree with, absolutely cross the line and is inappropriate. But I would, until it is Mr. Montez Merriweather, WWE slammed, kicked someone in the head. That's what the court is here for him specifically, not this they, the fight. That's the whole problem with this whole case. And I brought the body camera footage, again, I have what I have, showing the individuals saying, smoking cigarettes, we don't need medical attention. So I appreciate Mr. Guinan's representations, but everyone's opinions about this case don't matter. What matters is what did he do that day for this court to set a bond? And that's what I'm asking for the representations to be made.
Well, we were hoping to have that compilation video here today so that everybody could see it and there would be no question as to what happened. Because again, people are only seeing whatever videos are posted out there on Facebook, so they're not reliable and they're not indicative of the entire situation.
We agree.
So again, Mr. Guinan indicated that he's the only one that's seen the entire start to finish of this incident.
Thank you for your patience on his record, Your Honor. In 2008, 2009, he was convicted of aggravated robbery, served a prison term of 7 years. That was his most recent conviction.
When was that?
2009, sir.
Okay.
Sentenced by Judge Nadel.
And he served 7 years on that?
Yes, sir. Looks like it was 2 counts, concurrent time of 7 years.
All right, anything further?
Just, Your Honor, that he was not present at the bar that Mr. Guinan referenced. He was there with his family and they were going to the food truck when this began. But I would also ask that the record reflect, if the video could be submitted to the court and the court takes it under advisement, that's how confident we are in his actions that evening.
Oh, we will always review the bond.
I appreciate that.
Yes.
Thank you, that's all we have.
All right. Based on the fact of his prior record, the allegations, the fact that he has a federal holder and he was out on bond when this occurred, the bond will remain the same. Do you need me to read that into the reference bond? What are the current bonds?
500,000 straight with DMD.
With the MD, right?
Kyra Vernon.
Good morning. Defendant, state your name for the record.
Clyde Bennett on behalf of the defendant, Ms. Vernon.
This is case number B 25-04011-B to Kyra Vernon. You've been indicted with 3 counts of assault, 2 counts aggravated riot, and 3 counts felonious assault. Have you received a copy of your indictment?
She has pleaded not guilty.
State want to go first as the bond.
Your Honor, we're asking to keep the same bonds. My understanding, Ms. Vernon's bond is $200,000 with EMD if she's able to post that. I'm not asking to raise the bond, even though there has been additional charges. Again, I'll say this for every defendant, the grand jury added 2 counts of felonious assault and 2 counts of misdemeanor assault against Ms. Vernon. When she went through May, she only had 1 such count of each, as well as an aggravated riot. I think that the bond is appropriate for her involvement here. And with that, we'd ask you to keep the same bond, Judge.
The officer didn't mark bond preference. Officer, you're here today. Is there a bond preference?
Keep it the same, sir.
Okay, thank you.
I'm sorry.
Mr. Bennett?
Judge Triggs, the bond is not appropriate. The bond is it's unconstitutional, inconsistent with the law, specifically Ohio Revised Code 2937.011. There was a bond reform, and the legislators came up with factors and came up with laws to determine what is an appropriate bond. That is what's glaringly absent in these matters, is the law. The catalyst for the bonds in this case is race and politics, not the law. If you concentrate on the law, there's no way this woman should have a $200,000 bond for what she's charged with and what they claim she did. The law says that the court should release the defendant on the least restrictive conditions, and the financial condition should be least costly. That's what the legislators have said. So you look at factors to determine what is the appropriate financial bond and what would be the appropriate conditions. The nature and the circumstances of the crime charge. She's charged with felonious assault, and she's charged with aggravated rioting. She's charged with felonious assault under the umbrella of complicity, and aggravated rioting because they claim that she participated with others with the intent to commit a felony. When in fact, the nature and the circumstances of this case, a blind man can see, and everybody in this city knows, if you remove race and you remove politics, this is a fist fight and a brawl that was fueled by alcohol consumption, and that was initiated by some of the alleged victims. So this is a typical fist fight case that you have in Cincinnati time and time again. This case is being treated differently and inappropriately because of race and people trying to acquire and obtain political gain for the selfish reasons. It's aggravated rioting, that's the charge. It's felonious assault. They don't claim that she committed felonious assault individually. They claim that she's one of another, and she's combined with other individuals to be complicit or to go out and commit crimes with others to assault this young lady that was unfortunately knocked unconscious. That's not the case. If you look at the video, she didn't do that. It's not a planned, contemplative crime. It was a reactionary fight by some drunken individuals. What is the weight of the evidence against this defendant, Ms. Vernon? Nothing indicating that she participated with others or intended to commit a felony or act of violence. Again, it's a non-contemplative, spontaneous fight that unexpectedly broke out. There's no meeting of the mind for complicity. It happened out of the blue. It happened randomly. Aggravated rioting is the January 6, 2021 attack on the United States Capitol. That's a riot. When you get together, you assemble, and you plan to commit a crime. That's not what happened down on 4th Street, Judge. So the weight of the evidence and the nature of the circumstances against this defendant for aggravated rioting is weak. And felonious assault, again, there's no complicity here. It's weak, and they don't claim that she individually committed felonious assault. She individually committed assault, but because she's allegedly with these other individuals, it's complicity. Yeah, it's not there, Judge. The other factors is strong family ties. She lives with her mother. She's gainfully employed. She has limited financial resources, good character, no criminal record, no acts of violence. She's in good mental condition. She can focus on any condition that the court will order and comply with them. The length of residence in the community, strong ties to Cincinnati, has only lived here her entire life here in Hamilton County. What is her criminal record? Record of convictions? None whatsoever. What is her record with respect to appearing in court? She has no criminal record, but she also has no cases or warrant of failure to appear history. Then she wasn't on parole, wasn't on probation, not under the auspices of the government in any way when this crime allegedly happened. So why is her bond $200,000? Why is it $200,000? Because of race and politics, or race and politics has no it should not be considered in a court of law. That's the imperative of judicial integrity. It's unconstitutional to consider race. It's strictly prohibited by the United States Constitution. It's studies by the Ohio Supreme Court have said the issue of race and racial disparity still exists in the state of Ohio, and this is an example of it. It's wrong, and I'm asking the court to make it right by giving a bond that does not consider race and does not consider politics, a bond that is consistent with the law, consistent with her history, and consistent with what she allegedly did. And I think that bond would be, and I'm going to echo the sentiments of Ms. Deardorff, because I've looked at the other felonious assault cases and the aggravated rioting cases, and a bond typically for a young lady like this is an OR bond with a stay-away order. And that's what I'm asking for.
Yes, sir.
Several points, Your Honor. This is my case, and for Mr. Bennett to say to the public that this case is driven by race and by politics is clearly offensive. I've known Mr. Bennett close to 30 years. He knows for a fact I don't have a racist bone in my body. I did his job for almost 20 years. We've had cases against each other. We've cases with each other. And for him to sit here in open court and say that this case is driven by race and politics is beyond the pale. He also misstates the characterization of the conduct his client is accused of. And he has not had the opportunity to review all the videos, as I've told the court I have. She is in direct physical contact with the victim on count 6 felonious assault and clearly on count 8 the felonious assault.
Count 6 is HR.
That's GN, Your Honor.
So not HR?
HR is count 8. She's also directly involved with HR.
Okay.
She strikes both of them several times. And let me be clear, this particular defendant interjected herself. She was not part of the original fight. She was down there and retrieved several items of property from one of the co-defendant's vehicles that was parked out front. And when the actual assault broke out, she was on the perimeter. As the fight progressed, she interjected herself. These people had no contact with her, yet she saw an opportunity. She jumped into the melee. She kicked, she stomped, and had direct contact that caused concussions to these 2 particular victims. That are the facts. I'm not here to grandstand. I'm not here to state what I think this case is about. This case has nothing to do with race. This case has absolutely nothing to do with politics. I'm the most apolitical guy you'll find. This case is about what these people did, what these victims suffered. The bond is appropriate, and I ask you to keep it the same.
Judge, the last thing I'll say is this. A lot of respect for you, and that's not a personal indictment or accusation against you. Law enforcement, politicians, this case wouldn't be here but for race and politics. It's not an accusation against you, and I think everybody practicing law in this courtroom knows it. So I would ask that she have a bond that's based on the law and nothing else, and based on what she's accused with. He gave a description of what he believes she did based on his observation of the videos, which we have not seen. That's not before the court now. That's his opinion. It still doesn't change the nature and the circumstances of the crime. And what the legislator said, high bond if a weapon is involved. He didn't say a weapon was involved. And you still have her behaving in a manner that's consistent with misdemeanor assault by punching and kicking somebody, whether she did it on her own volition and it wasn't necessary. The claim is that she punched and she kicked someone. So a $200,000 bond for that alleged conduct is excessive and unconstitutional.
All right, the bond will be set at $25,000 at 10%. That would be with EMD.
Thank you.
I'll give her open hours to go to work, to do what she needs to do. She is to stay away from downtown. You understand?
Thank you.
All right. So she will be, oh, I'm not finished yet. Sorry. If she tampers with her monitoring unit in any way, or is in the downtown area outside of her hours in any way, according to EMD, her bond will be immediately revoked, and she will be held without bond until the trial.
Thank you.
Are we clear?
Yes.
All right, thank you.
We're doing that.
Gotta go to Mr. Matthews.
This is Dominic Kittle.
No, Jermaine Matthews, number 36.
This is case number B25-04011-C, Jermaine Matthews. You've been indicted with 3 counts assault, 2 counts aggravated riot, and 3 counts felonious assault. Have you received a copy of your indictment?
He has,
Ready, please?
not guilty.
State.
Kip, on behalf of the state, Your Honor, we're asking you to take a look at the bond for Mr. Matthews. And I want to be quite clear, it's not because he is the only person that posted bond. Rather, we're asking you to review the bond based upon the fact that, again, the grand jury added some serious counts here. When Mr. Matthews was first arraigned in room A, he had 2 counts of felonious assault and the aggravated riot and 2 counts of assault. The grand jury has added a count of felonious assault and a misdemeanor count of assault. I know he is present here today, represented by counsel, whom I've been in great contact with. However, I think the court should review the bond due to the fact that he's never been arraigned on these newly added charges, obviously the most serious being an F2. I can tell the court Mr. Matthews was one of the main instigators of this event. That is going to be proven by video. He is, if not the first, he is one of the first 2 that strike prosecuted with his GN. He was the instigator. He was, quote unquote, the leader and had some of the most involvement in this matter. As I indicated to the court before, there was a co-defendant, Ms. Vernon, who was just before your honor, that was getting items to and from a car. We believe that vehicle was Mr. Matthews' vehicle. He had several vehicles parked on that corner, which seemed to be his main concern. He felt that this was his corner. And he and another co-defendant, who was yet to be heard this morning, approached these individuals, told them they were at the wrong, quote unquote, the wrong party, and that they were going to make sure that they got off that corner, and that's what they did. I would ask for a bond increase commensurate with an F2. I'm not overly concerned with the misdemeanor assault, but I wish the court would review it based upon the addition of a felonious assault count by the grand jury. Thank
All
you.
right, the officer did not check bond preference. Do you have a bond preference, officer?
Aye, sir.
All right, thank you.
And for the record, Your Honor, it's Detective Larry Johnson, CP.
Yes, sir.
Thank you, Your Honor. I'd first like to start with flight risk. When this initially occurred, Mr. Matthews found out that he had a warrant for his arrest because FAU, the Fugitive Apprehension Unit, delivered a business card to his address. Immediately, he contacted me, I contacted FAU, and we arranged a situation where he could turn himself in that same day, and that's what happened. That was for officer safety and Mr. Matthews' safety. The following morning, he did have a bond hearing on simply a misdemeanor and a low-level felony. And he was given $100,000 secured with 24/7 EMD lockdown. He couldn't post the bond at the time. The following morning, Mr. Guinan is correct. Additional charges were added. Those were very serious. He was given a $170,000 increase. So a total of $270,000 secured with 24/7 EMD, no weapons, etc. His family was able to post that bond through a bondsman, money the court knows he'll never get back. He also came here today knowing the political climate, the attention this has gotten on the media. He knew there's a chance he could get locked back up today, but he's here. He's proven repeatedly he's not a flight risk. As to a danger to the community, you could look at his record, Your Honor. He's a
Tell me about his record, Mr. Prosecutor.
Just reviewing it, Your Honor, I think his last felony contact was for trafficking and possession of drugs. I believe he did a sentence of 1 year.
When was that?
I'm sorry, Your Honor. Originally arrested 12/27 of 08.
So his last contact with the court was,
It's strange that the disposition,
15
it's
years
an 08, I'm sorry, Your Honor, it's an 08 case number, but the disposition, and it may just be a clerical error, says 2012, but I can't imagine a drug case taking 4 years.
I'll clarify it, Your Honor. He was charged in 2008, indicted in 2008. In 2009, he entered into a plea agreement in which he did 3 years of incarceration. So that explains why he was released in 2012. But that's his only felony conviction, is trafficking in drugs. And again, released in 2012, here we are in 2025, no prior felony charges. There's
No crimes of violence, no weapons.
You got it, Your Honor. No domestic violence, no assault, no full felony assaults, nothing. He's not a danger to the community. And again, we're not trying the case, but my client is the individual who was slapped by the white man who has not been charged. I know that there were several skirmishes that day. We vehemently disagree with the argument that he was trying to get someone off of his corner. He was there legally operating his business. That's why he had 3 vehicles there. Again, irrelevant, but that's why he was there. When we talk about change in circumstance, that's what we're looking towards. What is the change in circumstance since he was arraigned on that $270,000 bond?
Let me slow you down a minute. Are you asking me to keep the bond the same?
I am.
Or are you asking me to lower it?
Keep it the same.
Just don't raise it.
Yes, Your Honor.
Okay, go ahead.
As it stands, it's already outrageously high, but he was able to post it. The change in circumstance has only benefited Mr. Matthews. We've had the release of the video of him being slapped, release of the video of him being called the N-word. And then what Mr. Guinan doesn't know is that there was an eyewitness that came forward who was present, saw the entire incident, and contacted our office. She has video from that day that has not been released, but it'll go through discovery. And what she plans to testify to is that the white individual in the green shirt was standing on the corner with 2 women. He got engaged in a verbal altercation with a separate defendant. That man then left that corner where Mr. Matthews and his car were and retrieved the 2 other white individuals, the males. They came to that corner looking for a fight. They began kicking Mr. Matthews' cars. So yes, Mr. Guinan, he was concerned about his cars because those individuals were attacking his car for no reason. That was the catalyst of everything that happened. It was a mutual combat. It was a brawl. He's not a flight risk. He's not a danger to the community. He's paid a substantial bond for this charge, as Ms. Deerdorf and Mr. Bennett have noted, and we'd ask the court to keep the bond the same.
A couple of questions. Is he working?
He is.
What is
Well,
it?
let me correct that. EMU won't even let him
I
go to his
understand.
mailbox.
That's what I'm getting towards. I need to know where he works.
We'll provide all of that.
Okay. I need to, show me.
We
So
will.
where does he work?
We plan to do that through Judge Hathaway, Your Honor. Again, with the cameras here, I don't want to put his business affairs out there. I've seen documentation and proof of his business, but with the death threats that we have received, I don't want to put his business name out on national.
Do you have the documentation? I can read it or
I have the names in my notes.
write it down.
May
I think I have it on my sheet, but I just want to make sure it's accurate. You want to show that to the prosecutor? Anything further from the prosecution?
Briefly, Your Honor, thank you.
Go ahead.
Mr. Fox made reference, and he's the first counsel to do so, about this infamous quote-unquote slap. I want to let the court be aware, at the time of this contact, GN had already been assaulted by 2 individuals, including this man here. He was hit from behind by Mr. Matthews and another individual. He was kicked from behind. So this assertion that they started this is completely not supported by any of the evidence that we have at this point. This man was wearing a red shirt. You can see him throughout the entire video. His conduct is violent. His conduct is more than mutual combat. He instigated it, he performed and participated throughout the entire beating, where 3 people suffered serious brain trauma. We blow off concussions, oh, it happens all the time. There's my time. But I want the court to be aware that this is the man that started. This is another false narrative through the media, through the release of people's social media. That so-called slap was 47 seconds already into the assault. Already into GN being beaten for no reason by at least 2 individuals. The grand jury in their wisdom added a felonious assault. I think it's important the court consider that, and I'm asking you to set a bond on those new counts. Thank you.
All right, the monetary portion of the bond will remain the same. As far as the EMD lockdown, I'm going to give Mr. Matthews the opportunity to remain employed. So he will be allowed out only for employment purposes and also visit counsel and for court appearances.
Thank you, Your Honor.
Thank you.
This will go ahead and put it
That's that.
Kill, yes, sir.
This is case number B25-04011-E, Dominique Kittle. You've been indicted with 3 counts of assault, 3 counts felonious assault, and 2 counts aggravated riot. Have you received a copy of your indictment?
Yes, please, not guilty.
State as the bond.
Kip Gunn, on behalf of the state of Ohio, Your Honor, we're asking the court to re-examine Mr. Kittle's bond as well. Not to be redundant, but grand jury added 2 counts of felonious assault. He was originally arraigned in room A. He had 1 count of ag riot, 3 counts of misdemeanor assault, and 1 count of felonious assault. As I indicated, the grand jury, after hearing the probable cause in this case and reviewing the evidence, has added 2 counts of felonious assault. I can tell you that this defendant was directly involved and had great contact with all 3 victims of the felonious assault. He also assaulted a 64-year-old man, knocking him to the ground. This particular defendant repeatedly, for lack of a better term, used a flying elbow, would jump in the air, came down with his elbow onto this victim's head on asphalt, at least twice, if not 4 times. My memory is not what it used to be, but it is directly attributed to this defendant. It was a vicious and savage attack on an elderly person who had done no harm to this defendant whatsoever. Again, Mr. Kittles, along with the defendant you just heard, instigated this entire event. They struck the original victim, GN, who had done nothing but standing on a corner waiting for an Uber. It is the state's assertion that Mr. Kittles, as well as Mr. Stewart, were the instigators of this entire event by striking this individual at least 4 times, all from behind. And I ask you to consider the bond on the 2 new counts of felonious assault. As for his record, I can address that after Mr. Evans is given an opportunity, and I'll look it up right now.
Mr. Evans, I didn't give you an opportunity to state your name for the record.
Joshua Evans for the record, Judge.
All right, go ahead.
Judge, I'm asking this court to lower this bond and release Mr. Kittle on a
Current bond is?
I believe it's $290,000 straight, Judge. I'm asking the court to release Mr. Kittle on an OR bond, or at the very least set a bond that's fair and reasonable under Criminal Rule 46. This court knows Mr. Kittle. In 2021, in case number C21CRB5651, the Hamilton County Court Clinic found him incompetent and unable to be restored based on his diagnosis of paranoid schizophrenia. Nothing about his mental health has changed, and I'd be willing to bet there's a lot more mental health issues that needs to be addressed once he's evaluated again. It's highly likely this result will be the same. He'll be found not guilty by reason of insanity. The videos from the incident also tell a very different story than the headlines.
So are you asking me to order a court clinic today?
I would like a court clinic, Judge.
All right, go ahead.
Mr. Kittle in this video is visibly scared. He's being chased. And excuse my language, he's being called nigger repeatedly all throughout the videos. Mr. Kittle tells me he was attacked off camera. This was a man not starting trouble. It was a man that was clearly in fear. And right now, while Mr. Kittle's being held in the Hamilton County Justice Center, he's not receiving his prescribed medication or the medical attention he needs for his condition. This is dangerous for him, and it does not serve the interests of justice to keep him in an environment where his health is deteriorating. This bond is also not consistent with how similar cases are handled in this courthouse. I've seen far more serious fights and altercations in this very courthouse where no charges were filed whatsoever. And what's troubling the most here is that there's one common denominator between the people who are arrested and those who walk away without charges. The arrested, they clearly don't have the complexion for the protection that these other individuals had that weren't charged. Bond is meant to ensure appearance in court, not to punish, not to respond to media pressure. This case has been overcharged and overpursued because of national attention. Mr. Kittle is paying a price before a jury has heard any evidence or anything of that nature. Mr. Kittle is not a flight risk. He's not a danger to the community. He has mental illness, no malice. Prolonged pretrial incarceration under the circumstances is not judgment. It's punishment before trial. And that's not the purpose of a bond, Judge. And for those reasons, we respectfully ask this court to release Mr. Kittle on an OR bond with the appropriate mental health conditions, or at least set a bond that truly reflects the facts, the law, and the purpose of bond. Thank you, Judge.
Well, I have some questions. My sheet shows that Mr. Kittle is homeless. Is that accurate?
He has a place to go, Judge. I've been contacted with
Where is that
the
place?
family. Judge, I wouldn't want to put that on the camera. I can come in.
I understand, but you're asking me to release this gentleman, and my sheet shows that he has nowhere to go.
I
Does he
understand.
have family members here today that can speak on this?
I've spoken with family members, Judge. I haven't spoken with them in the courtroom, but I'm willing to sidebar and tell you, talk more about what, if you're interested in those. I would not like to speak as what his living situation would be on the cameras. But he does have a home. If you were to place him on EMD, that he would be able to get a verified address.
Family members here.
His family in the back right here.
Right here. His sister has,
Judge, I've spoken with family members and they have indicated to me that he would have a place.
Well,
to go.
I'm asking the question. If I can't get the answers, I'm going to assume that he has no place to live.
I understand,
So
Judge.
if you don't want to tell me, then that's up to you.
Judge, his family in the back.
If they want to come and talk to me, they're more free to come talk to me.
Your name is the judge?
Tell me your name, ma'am.
Mary Kittles.
That's where he stands.
Okay. Go ahead, ma'am.
Judge, that's his mother, and he will be living with her, Judge.
Okay.
Yeah, thank you. Thank you.
State wanted to add his criminal record.
Yes, sir, thank you. Judge, he does have prior convictions for offenses of violence. Get to the page, I'm sorry. 2018 misdemeanor assault from Judge Kister he was convicted of. 2012 count of aggravated robbery, straight robbery in front of Judge Winkler, for which he did 2 years. So he does have a history of violence. But also, the state's concerned with his mental health. I think his conduct, what his own counsel has admitted to here, is having mental health issues. He creates a grave danger to the public. As the court is aware, these people were strangers to him, and he participated in viciously beating them. Mr. Evans is the second counsel that claimed that this case is based entirely upon race, drawn upon the complexions of the people. Again, for the purpose of the record, I find that highly offensive. I've known Mr. Evans his entire legal career. I worked as a mentor for him in some respects. I have presented this case. It is my decision of who got charged as the chief of the criminal unit. I have reviewed all the evidence, which he has not done. I can again tell the public this case has zero to do with race, has zero to do with politics. It has to do with the consequences of viciously beating people standing on the corner waiting for an Uber, causing them traumatic brain injuries, for being in the wrong place at the wrong time, for being at the quote-unquote wrong party. This bond is appropriate for this individual's conduct, this individual's record, and this individual's threat to the public safety. Thank you.
And Judge, Mr. Bennett said there's no personal accusation against you, Mr. Ganem, but
Words have consequences. Mr. Evans.
everybody knows Mr. Kittle, and he is not a danger.
Well, apparently he needs to be evaluated, so we're gonna figure out how quickly we can get him evaluated. All right, if you wanna state your name for the record, everything's being recorded.
Suzanne Christian,
And your position here.
mental health liaison for Common Pleas Court.
All right, and you telling me we can get him evaluated in 30 days?
Yes, sir.
Okay. Thank you.
Judge, if it is of the court's concern, if you release Mr. Kittle, he will have, make sure he,
That's not how I do things, Mr. Evans. If we're going to evaluate him, we're going to keep him until the evaluation is complete. Mr. Prosecutor, do you want a no bond hearing on this, or do you just want to keep the bond the same?
I just keep the bond the same, Your Honor.
All right, we will keep the bond the same until he is evaluated. After we get that evaluation, we can revisit the bond.
thank you, Judge.
All right,
Thank
matter
you.
of procedure, will that report then be coming to Judge Hathaway? I know she's
It will.
gonna sign the case. I don't think we have a DSC date yet.
We don't, but it will in 30 days.
Gotcha. Thank you.
Oh. You wait ahead of me. Thank you.
Good morning, Your Honor.
You want to give me one moment?
Yes, sir.
Yeah, you were doing that. I forgot that. Good morning, state your name for the record.
Bernard Mundy on behalf of Mr. Vaughn.
Case number B 25-04011-E, Aisha Devon. You've been indicted with 3 counts assault, 3 counts felonious assault, and 2 counts aggravated riot. Have you received a copy of your indictment?
She has, it's Aisha Devon,
How do you plead?
not guilty, Judge.
State as a bond.
Your Honor, as the bond, I was actually considered, again, grand jury added some charges against Ms. Devon. When she was arraigned in room A, she had 2 counts of felonious assault and an aggravated riot. The grand jury has added a count of felonious assault as well as 3 counts of misdemeanor assault. I think the bond should be reviewed.
What is that current bond?
I have it as 300,000 total.
It's 300,000 secured plus EMD plus church as requested.
Go ahead.
Her record is minimal, Your Honor, no prior felony convictions that I can see. However, she is another individual that engaged herself. She was not the original skirmish between Mr. Kittle, Mr. Stewart, and our prosecuting witness by the initials of GN. She was also retrieving and going in and out of the motor vehicles of a co-defendant. And when that co-defendant was involved in a more serious altercation, she interjected herself. She specifically struck GN, kicked him several times while he was already on the ground, stomped on his head on several different occasions, all on video. She also struck HR and participated in holding her down, which led to her being unconscious, which is the video that everyone has probably already seen. The record is clear, she was directly involved with assaulting both of those individuals. And she interjected herself. She had absolutely nothing to do with it until she decided to run into the melee and cause this physical harm to these 2 people. Both suffered traumatic brain injury. So although she has no prior felony record, I do believe she's a threat to the general public. And I'm asking the court to at least review the bond on the added counts from grand jury. Again, 1 count felonious and 3 counts of misdemeanor assault. Thank you.
Officer, you didn't mark bond preference. You want to state your bond preference?
My bond, sir.
All right, thank you. Yes, sir.
Your Honor, with regard to Ms. Devon's bond, I think it is punitive and it's not reasonable for the charges she faces and based on her background. She's 26 years old. She lived in Cincinnati all of her life. She attended Woodward High School. She earned her high school diploma at Dawn. She was, at the time of her arrest, a chef at Great American Ballpark, working for the Reds since the beginning of the baseball season.
You're having a hard time hearing.
I'm sorry, Mr. Mayor, I can't hear you. I come up there.
It's okay, of course.
Where are we going to be?
You want me to start over?
No, keep going.
Her first job was with the Great American Ballpark, a chef with the Reds since the beginning of the season. Her second job was a driver with a company called Emote. Those places of employment are certainly at risk. She has a 6-year-old daughter she's the residential parent for. She has some college credits. You heard her lack of criminal contacts stated by Mr. Guinan. She enjoys the presumption of innocence at this point. We have actually only got over probable cause. The indictment has no evidentiary value. I'd ask the court to consider a bond similar to Ms. Vernon's bond.
Yes, sir.
Your Honor, again, she stands out, particularly in this incident. She's wearing a bright white dress. Unlike Ms. Vernon, I can submit to the court based upon the video evidence, she clearly stomps on the head of GM repeatedly. And I will stress to the court that was while he was already beaten down and he was laying prone on the asphalt in the middle of 4th and Walnut Street. I think she is, despite her lack of record. I don't know if alcohol was involved here. I don't know if it was just terrible decision-making, obviously, but she is directly involved in traumatic brain injury caused to 2 individuals that did absolutely nothing to her, had no contact to her whatsoever.
You spoke of her record. What is her record?
I don't have any record locally, Your Honor. I mean, she has some traffic offenses, but no prior felonies from what I can see.
May I be heard briefly?
Of course.
Judge, I believe
I don't know if Mr. Guinan was finished though.
Oh, well, that's fine. Thank you.
Because I think the 300,000 Superior plus EMD plus jurors have requested is out of step. It is not reasonable. It seems punitive. It's tantamount to no bond. Her mother's here. They attempted to arrange bonding, couldn't even get it arranged through a bail bondsman. So I'm asking the court to consider reducing the bond to 25,000, Judge, something similar to Ms. Vernon's bond. I understand what the prosecution states he anticipates proving in trial. We're not there yet. This is not the time for punishment. She's not a flight risk. She has a 6-year-old daughter who she's a residential parent for. So I think it's inappropriate and just out of step with the means of justice to hold this bond at 300,000 secured plus EMD plus jurors.
Can I rebut that? If you're going around assaulting, causing traumatic brain injury to people you've never met before, because the opportunity presents itself, you are clearly a danger to the public. And that's one of the factors the court can consider.
The only thing I would add, Judge, 6 co-defendants at this particular time, so it remains to be seen who's going to be responsible for the injuries.
She has absolutely nothing on her record. How old is she again?
26 years old, Judge. 6-year-old daughter at home.
Who's taking care of her daughter now? Who's taking care of her daughter now?
I assume her mom. She's raising her hand. You can see her in the red top in the back.
And again, I've been reading a lot and a lot of things are being thrown at me. I don't know if I caught, was she employed?
She had 2 jobs, Your Honor. Now,
I know you said Great American and
And then the second, she was a driver for Emoke, E-M-O-K-E.
I'm just making a record so that I know what I'm going to do. Since she is employed, no record, I understand the allegations are extremely bad. I'll make her bond 25,000 at 10%. She will be on EMD with work privileges only. Of course, she can attend meetings with you and come to court.
Thank you, Your Honor.
Your Honor, it's my understanding that Mr. Roseman had a competition back. It's a partner. Your Honor, it's my understanding, the F defendant, if you will, Mr. Patrick Roseman, he was the individual that was picked up in Atlanta, Georgia. He was not brought back in time, so we do not have him on the docket. I just want to make the court aware. I don't know if we'll do it tomorrow or next week, but I'll work with the sheriff's department. But I just want to make sure you're aware, he is not ready for today's docket.
He's not over in Jackson.
Your Honor, he was supposed to return last night from PTS. They give you a date that they expect to return. If they get a phone call to pick somebody up on the way back in a different state, they'll swing over and pick him up. So we do not have an ETA on his arrival yet.
What is his current bond?
He has not had it on set. He never went through remand. He was, in essence, indicted through direct hearing because he absconded to Atlanta.
So what's holding him?
I believe there's a current holder for the indictment that's been issued. Warrants have been issued, and that's why they're bringing him back. He was recovered by the FAU units as well as federal agents down in Georgia.
Okay, is he represented?
Not yet. I
Not
imagine
yet.
the public defenders, or he will retain someone when he returns to the jurisdiction. I originally thought he was going to make the docket today, but due to their detour, if you will, he's not on the docket. I just want to make sure we're all on the same page.
Okay, all right, so we'll try to get him on for tomorrow. If not, it'll be next week.
Yes, sir.
All right, thank you.
Thank you, and I appreciate your time this morning.
I keep giving you all my papers and everything else.
Hey.
Yeah.
These doctors are
Well, then we have to wait. We're moving on. Is there anything new? Have you been already set up? Okay, thank you.
Yeah.
Appreciate it.
Josh, can you say something? Yeah, give me a second, we're on the wrong speaker. All right, can you say something again?
Yeah.
Here. There we go.
All right, good morning.
Good morning, Judge.
Just for the record, who I have on camera.
Linda Reinhardt from the state.
Josh Hitch, and I have with me Ryan Ransom, call number 17.
This is case number B 25-03975, Ryan and Ransom, given indicted with 1 count aggravated possession of drugs, 1 count failure to comply with an order or signal of the police officer, 1 count possession of cocaine, and 1 count possession of a fentanyl related crime. Have you received a copy of your indictment?
Yes.
And how do you plead?
And I plead not guilty on behalf and ask that Luis Suarez be appointed to represent him.
Okay. Has the bond?
Judge, as the bond, Mr. Ransom is 39 years old. He does live locally with his aunt. Since he's been in the jail, he has gone on the MAT program and does work in the commissary. So he has taken advantage of his time here to sort of get a jump start on the type of programming he will be going through. He's been accepted into the drug court program. That's why we're asking Mr. Suarez to represent him. I'll note that there was an F3 when this came through room A. The failure to comply was at an F3 level. The grand jury amended that down to an F4. He is today facing all F4s and F5s.
Slow down. I still have it as an F3. Did they amend it down from F4?
The sticker says F4, let me look at the actual F4.
F4, right, thank you.
As noted, he is ready to go to the drug court program, ready to work with them, ready to work through all of this. With it being a treatment-based program, we are asking for a non-financial bond with any conditions the court may wish to set, but he would like to be able to get out and work that program in the community. So we are asking for a non-financial bond, any conditions he would be available to.
All right, the officer did not mark a preference states.
I don't have anything to charge.
All right, the OR with EMD. That'll be standard EMD. You getting mad at me because I'm writing on your papers?
No.
Oh, okay. What's going on, sir? What do you have today? Oh, really good, that was-
Thank you.
Judge, I have with me Mr. Longshard, call number 21. Mr. Attorney, sir. Morning.
This is case number B 25-03988, Brandon Longshore. You've been indicted with 1 count domestic violence. Have you received a copy of your indictment?
Aye. Yes. Yes.
How do you plead?
Not guilty.
State your name for the record.
Marina Marinakis for Brandon Longchart.
All right, do we have the alleged victim here?
We do not judge.
All right, was she notified to be here?
I do not believe so, Judge.
Did we comply with Marcy's law regarding her rights?
I believe we did, Judge.
Okay. Go ahead, ma'am.
Your arrest bond, I believe the cash component of this bond has been posted. So it's either the jurors or the EMD that is holding my client. If it's the jurist portion that's holding him. He's been held for over 10 days, giving the state plenty of time to reach out to this prosecuting witness and have the jurist set up. That said, in reading the information that was provided to me, it looks like when my client was taken into custody, he was transported to Bethesda North Hospital to be examined. Only after being medically cleared was he transported to the Justice Center. So we're asking the court to probably remove the jurist of this. I believe there's a TPO in effect. Mr. Longshot understands absolutely no contact with this prosecuting witness. So we're just asking you to take into consideration this morning.
You understand that, sir? No contact with the prosecuting witness?
Yes, Your Honor.
Um,
I'll be staying with my mother in Silverton. She's the one who posted the bond for me too.
Okay, what is the alleged relationship?
So the allegation is, I believe they were dating at some point. I do not believe they have children together.
Okay.
My understanding is that the officers got called out for domestic trouble. At that time, the defendant had already fled the scene. Officers noted that the house had been, it was clear there was a physical struggle inside and that she had bruising on her back from items that he had allegedly thrown at her. And it looks like he also has prior convictions in other counties besides Ohio besides Hamilton for domestic violence type of situations. I will note for the record, she was present in grand jury with her mother and her adult sister and her mother. The no contact not only applies to her directly, but through her family members, because my understanding is they were told in grand jury, the prosecutors, that he has been calling her family members trying to locate her as well. So there was some concern from the grand jury prosecutors about the continued attempted contacts.
Right. I'm a little concerned about his record. However, it's been 10 days and we've had no contact with the prosecuting witness regarding the jury.
That would be my understanding, because if he has a place to go that is okay for EMD purposes, then EMD should have released him. I mean,
No, the jurist.
That's what I'm saying. So it's either EMD or jurist. The EMD part of it should be settled. We have phone numbers for the victim, so, and she clearly showed up for us, so I don't know what the problem is as far as making that connection.
All right, I'll keep the bond the same, but I will remove the jurist component.
Thank you, Your Honor.
All right, thank you.
Excuse me, Judge, was that 50,000?
It was 50,000 plus EMD, 10%.
Judge, I have with me Mr. McNear, call number 27.
Case number B25-03998, DeMonte McNear. You've been indicted for count breaking and entering. Have you received a copy of your indictment?
She's talking to me?
Yes,
ma'am. Yes, ma'am.
How do you plead?
It's not guilty.
Officer wants a high bond. Tell me why I'm not a prosecutor.
So my understanding is the officer appeared in room A, and while these are F5s and breaking and enterings, he has multiple priors of the exact same offense. I'm trying to count, I'm looking at 10 right off of 2 different pages. I mean, that's basically his whole record is theft related, B&E, robbery. And I think he was just given 2 years in 2023 by Judge Allen. Community control for 2 years by Judge Allen in 2023. So I'm not sure this role to Judge Gehring, so I guess he's done with probation in that respect. But I know the officers did appear and they were very adamant about keeping him locked up.
Yes, ma'am.
Just for the record, Maria Marinakis from Mr. McNear. Your Honor, it's a $25,000 at 10% times 2. So basically he would have to post $5,000. He does not have the financial means for that. Indicates to me he would be residing with a family member. Indicates to me that by trade he is a painter and was working full-time. I think from his record, Mr. McNear understands how important it is to make court appearances. And when I talked to him, he assured me he would make court appearances. We're just asking you to consider it as far as bond goes.
I show 18 prior convictions in the past 4 years. All right, we'll keep the bond the same.
Thank you, Your Honor.
Thank you. Keep my, I don't want to give it to her.
No, we're out of our, we have no flow.
Judge, I have with me Mr. Anderson, call number 28.
Case number E25039999, Israel Anderson. You've been indicted with one count having weapons while under disability and one count aggravated possession of drugs. Have you received a copy of your indictment?
He has, Your Honor.
How do you plead?
Not guilty.
All right. There's no preference on the bond from the officer.
This is the difference in signing paperwork. I don't have the 527, so I can't see.
Get station name for the record.
Amy Dish, on behalf of Mr. Amison.
Go ahead.
Your Honor, as to bond, Mr. Amison is 20 years old. He's got no adult record whatsoever. This alleged disability here is based on a juvenile conviction. He's got no failures to appear for court on his pretrial paperwork. He lives with his mother here in Hamilton County. They've been at the same address for about 2 years. He was working at McDonald's. Unfortunately, he lost that job, but if he is released, he will be looking for work, Your Honor. He does not have much money for bond at this time.
Let me ask a couple of questions. We can get there quicker. Does he have any adult convictions? You said no, right?
I said no, yes.
Right. And this is because of a juvenile adjudication
Yes,
and no prior weapons under disability charges.
correct.
All right, or bond.
Your Honor,
I think he is on
he does
probation
have a
to
holder out of
Butler
Butler County
County.
for a probation violation.
Yeah.
All right, they'll come and get him then. And they'll come back.
I think, I forgot about that, but I think that's for disorderly conduct. So,
Right, they'll probably just recite it and
Yeah.
come back.
thank you.
All right, thank you.
Your Hayes. Hayes. Judge, I have with me Mr. Hayes, call number 40.
This is case number E25040140 You've been indicted with one count for impersonation of a police officer or private police officer, one count menacing by stalking, one count aggravated menacing, one count telecommunications harassment, and one count intimidation, witness, victim, or attorney. Have you received a copy of your indictment?
Counsel?
Copy the indictment.
You're
You're charging. Yes, I will.
Jeff Gavin here on behalf of Mr. Hayes. We would waive reading of the indictment, accept service, and enter plea not guilty at this time.
All right, that's the bond.
The bond judge, all but one of these charges are misdemeanors. His mother has been in contact with me constantly since he was initially arraigned. She's provided me with documentation about numerous mental health diagnoses that Mr. Hayes has. I believe influenced why he's in front of the court today. He also has an intellectual functioning disorder as well.
Do we need to order a clinic?
I've already filed them, but yes, I would like to, I already filed the motion, but yes, I would like to go to the judge. I do believe, I understand what the allegations are. He's not going to be able to post any bond. His mother does not have the finances, while she's very supportive, he does not have the money to post the bond. I would be requesting EMD lockdown. I believe that would make sure the prosecuting witness is not going to go near the prosecuting witness while keeping him, obviously, where he's not incarcerated. He can seek out services for his mental health as well as obviously prepare for his defense.
I never have faith on the defendants going to their appointments if I let them out. I let them out, and then they never make it to their evaluation. They were waiting on them to be evaluated, and then eventually I lock them back up so that they can be evaluated. So I'm going to keep the bonds. Go ahead. Yes,
Grand jury asked me to actually raise this bond and add, let me see, okay, there's jurors. I don't know if he doesn't have the ability to stop his behavior. He was calling her while she was sitting on grand jury. He is following her and her grandmother around. He's taking pictures of her grandmother outside of the house. He's threatening to kill her and her grandmother. So I definitely do not want him released pending any kind of evaluation, Judge.
Right. Okay. I don't think he's going to be able to make this bond anyway, so we'll keep the bond the same pending his evaluation.
Thanks, Judge.
Thank you.
Judge, I have with me Mr. Whitaker, call number 40. 43.
That's not who I had.
Oh, sorry, that's who we-
This is case number B 25-04019, Carl Whitaker. You've been indicted with 2 counts of theft. Have you received a copy of your indictment?
He has,
Have you please?
not guilty. And for the record, Your Honor, Darcy Winston on behalf of Mr. Whitaker.
Thank you. State, what have you heard, that's the bond?
No, Judge.
These are all non-violent.
The-
What was that?
There is a warrant, a hold to Warren County for Marcy.
What do you want me to do? You want me to keep him here until we resolve these, or do you want to let him go to Warren County?
We're asking for an OR bond. I did meet with Mr. Whitaker earlier this week to talk about that Warren County holder. He would like to get that resolved. There are 2 thefts, but they're both minor thefts. They're just from 2 different dates, Your Honor. I do have a good place he could stay once he's permanently released.
I feel that he's homeless. Is that not accurate?
It's not accurate, Your Honor. He doesn't have a stable address, but he's living with a friend. So he doesn't have his own address, but he's staying with a friend of his by the name of Josephine in Chevy off of Florida Drive. So he does have a place he can stay locally. We are aware of the holder, but these are 2 low-level nonviolent thefts from Myers. So we're asking for an OR bond. I think part of his bond was the condition of E&U, but the reality is that would keep him in limbo. So that's why we're asking for that.
It'll be supervised or,
And before you leave, just so he is aware, some of this is all minor, all of these charges, even the ones that were ignored. I was contacted by the Green Township Meyer because theirs got ignored and they didn't know why. That's probably going to come back through grand jury.
give me 1 second, hold on. Okay. Yeah, but, yeah. When you said Meyer, it brought up something.
This is not over to you. That is-
Yeah, okay, we're good.
Okay.
We're not saying guy.
Just so you're aware, and he's aware that, I guess the Green Township officer wasn't there that day, so the Cincinnati cases went through and the Green Township one got ignored. So that's probably going to come back through as a direct hearing.
Okay, do you understand that, Mr. Whitaker? Okay. Thank you for the heads up.
Thank you. I got all kinds of stuff that I'm not giving you back.
It's still court, and I'm like, you're really good.
Judge, I have with me Mr. Cook, call number 44.
This is case number B 25-04020, Leo Cook. You've been indicted with 1 count carrying concealed weapons, 1 count resisting arrest, and 1 count improperly handling firearms in a motor vehicle. Have you received a copy of your indictment?
He has.
How do you plead?
Plea is not guilty.
Just name for the record.
Jamila Bash on behalf of Mr. Cook.
Go ahead, bond.
As the bond, Your Honor, Mr. Cook is currently being held on a $41,000 bond. I think given the nature of the charges and the allegations, I think that bond is unreasonable. These are 2 F4s and a misdemeanor. Mr. Cook is 20 years old. He will turn 21 in the fall. He's a full-time father to his 1-year-old son. Judge, in addition to that, he is also a student. He's currently enrolled in a dual program at Scarlet Oaks, where he's getting both his diploma, but he will also earn a fiber optic certification. Mr. Cook has no adult record, therefore no failures to appear. He only has 1 juvenile adjudication, that's it. He fully denies these charges. Judge, as to the resisting arrest, Mr. Cook denies ever resisting. In fact, he tells me like during the search, it got a bit personal. His genitals were touched, which is why he tensed up. It was just a natural reaction to what was going on at the time. There's also apparently 3rd-party video of this arrest. This arrest occurred directly outside of his home, Pleasure Drive, that also says that is the place of the arrest. And a family member was there and recorded everything. I have not yet seen that video, but I do know that video does exist. Additionally, Judge, this allegedly, the reason for all of this was an alleged traffic violation, but no traffic charges were ever charged in this case. So I do think the state may have some suppression issues down the line. We are asking the court to significantly reduce this $41,000 bond.
Anything from state?
The allegations that he was the driver of the vehicle and he was sitting on a firearm.
I'll give him OR with EMD standard.
Thank you, Judge.
Thank you.
Judge, I have with me Mr. Fee, call number 57.
This is case number B25-04051, Travis Fee. You've been indicted with 5 counts of possession of a fentanyl-related compound, 1 count possession of heroin, and 4 counts possession of cocaine. Have you received a copy of your indictment?
He has.
And how do you plead?
Enter a plea of not guilty on his behalf. Ask that Adele Gray be appointed to represent him. Josh Hitch on behalf of him for arraignment bond.
He's gonna be going to drug court
Yes, Judge.
as the bond.
Judge Esteban is 53 years old. He does have a local address with a significant other. He does have a holder out of Kent County that will have to go address if he does get out on this. He does believe he'll be able to do that. He does want to work with the drug court program. These are all F4 and F5 possessions, all below the bulk amount. We are asking for an OR.
Yes, ma'am. Supervised OR. Barney. Waiting on the Barney. They're not, nobody's checking the boxes.
Judge, I have Mr. Russell, call number 58.
Case number B25-04052, Cahill Russell. You've been indicted with 1 count of carrying concealed weapons. Have you received a copy of your indictment?
He has.
How do you plead?
Not guilty. For the record, Your Honor, Corinne Hill on behalf of Mr. Russell.
Okay. Esteban.
Esteban, Your Honor, Khalil is 18 years old. He has an address locally where he lives with a family member. His mom is here in court today to support him. He is working as well. He works at McDonald's. His mom picked up his most recent check for him 2 days ago. She did talk to management at that McDonald's about the fact that he's currently incarcerated. They indicated they would be able to hold his job for a period of time. So that's why we're asking for his bond to be reconsidered.
Let me slow you down a minute.
Yes.
I only heard that he was indicted on the carrying a concealed weapon. What happened to the domestic violence and assault?
I just have here that it's ignored, there's no votes on, it doesn't have any witness information here, so I don't know if they weren't notified, but they just have that it was ignored.
Okay, those were yours. Go ahead, I'm sorry to interrupt.
No problem, Your Honor. They are able to hold his job at McDonald's for a period of time, but of course not indefinitely. So if he's able to get out at this point, he would still have employment to return to. The main issue with his current bond, which I believe is $25,000 at 10% plus EMU, is the monetary portion of it. He's a hard worker, but we all understand that McDonald's only pays so much. He's not going to be able to post a financial bond. This is his first adult contact, and the issue here that what gave rise to this stop is just a jaywalking
Yeah,
violation.
the only reason that he is not allowed to have a gun is his age, right?
That's correct as well, Your Honor.
Yeah.
So for all,
I can,
No, go ahead.
no, I can clarify, it wasn't just jaywalking ticket, plainclothes officers doing what they always do. We're watching the area, saw him lift his shirt to wipe his face and saw a firearm sticking out of his waistband with an extended magazine. That's when they stopped him for the jaywalking and took him into custody. I will note that it says here in the paperwork that he has a pending CCW in juvenile court right now. And I misspoke earlier, it was the pedestrian ticket that got dismissed. The domestics, I don't think are connected to this in any way, and I just have here, as of 7:31, when this record was run, that was pending. So I don't know, those are municipal cases, so I have no update on the.
Well, they were all under this arrest. I just don't see them.
They're not on, they did not go through grand jury at all. There are only 2 things that went through grand jury, it was the
So
pedestrian.
do we have
ticket,
misdemeanor charges pending?
Possibly.
there's a domestic violence charge pending in front of Judge Johnson. We're set on Tuesday of next week to review his bond on that.
Okay, all right, thank you.
And Your Honor, I can add some additional context to the juvenile case that the state's brought up as well. I actually represent him on that charge. We were successful on a motion to suppress the stop on that case several months ago in juvenile court. There's an objection process that can take place at the trial court level. The state's objected to that ruling, and that's what's pending right now. But at this point, we do not anticipate that being an adjudication. That was already found by the court to be an unlawful stop. And it's my understanding that the exact same officers that were involved in that stop are the officers who were involved in this stop. So we anticipate a possible suppression issue on this stop as well.
All right, 2,500 at 10% with EMD standard. No weapons. Anything further?
Yeah, Your Honor.
All right, thank you.
Thank you.
All of these are missing though, besides 27.
I would say I'm not seeing any elements in here, is there? No.
Judge, we have with me Mr. Guevara, call number 74.
This is case number B25040878, Aura. You've been indicted with one count violating a protection order. Have you received a copy of your indictment?
He has, Your Honor.
How do you plead?
Not guilty. I'm covering this for Tom Maloney.
State your name for the record.
Oh, Edward Kaplan. Covering this for Tom Maloney, younger, better looking version. Judge, the notes that he sent me were that just asking for a lower bond on this. It stemmed from a TPO, I guess it was.
How old is he?
The TPS from 2021.
20, yeah,
How old is he?
Oh, sorry.
I have no clue.
I got a date of birth of 74.
51?
Yeah, that's what
Yeah,
it's showing.
1974.
No felony convictions,
No.
only
Misdemeanors.
misdemeanors.
It was 25 straight DMU. Just asking for a reduction of that bond. He cannot pose 25,000 straight.
You're okay with the EMD injures?
I would prefer that part, yeah.
No, I'm talking about, I know you want it.
Hopefully he is, because that would, it's a lot better than 25 straight.
All right, we make it 5,000 at 10 with EMD injures.
Thank you.
Judge, I have with me Mr. Kirksey, call number 75.
This is case number B250409, Leroy Kirksey. You've been indicted with one count possession of cocaine. Have you received a copy of your indictment?
He has.
How do you plead?
Not guilty. Amanda Tolkien for the record.
Tell me about the domestic violence. Is that in municipal court?
It's not tied to this.
I do not represent that. This is unrelated to that is pending.
Yes.
What is his bond on the domestic violence?
That I do not know. I just have
Do you
the
know?
case number. I can, do you want to look it up? Do you need it?
I apologize. I'm looking at it right now. I got it.
17 prior felonies?
Correct, but an ORAS of 2.
The domestic violence is an OR bond, and except for the 21st for non-jury in front of Judge Peck.
Anything from state?
No.
Or,
Thank you, Judge.
thank you.
Judge, I have Mr. Ferguson with me, call number 78.
Case number B250409, Sean Ferguson. You've been indicted with one count failure to comply with the order or signal of a police officer. Have you received a copy of your indictment?
He has, Your Honor. Please not guilty. Edward Kaplan for the record, covering for Tom Maloney. The notes Mr. Maloney told me is that there's also a fictitious plate charge under the name of Sean Ferguson. He said, basically, Mr. Maloney told me, he said his son was driving and took off. The police showed up at this Mr. Ferguson's house and arrested him. Judge Bender set the bond at $30,000 at 10%.
On the scale of OJ, Fast and Furious.
How fast they take off?
Yeah.
I'm probably going closer to OJ because there's no failure to comply attached with this. No even.
It is fair to comply.
Hmm?
It is a fair to comply.
Oh, it is fair to comply.
Yeah.
Well, shoot, see, he gives you bad notes.
I will say, it doesn't have any narrative. All I have is that he took off at a high rate of speed. There's no ran 8 lights, hit a car. There's none of that narrative going on. It's just,
He just left the scene.
yeah. And it says at a high rate of speed, but
All right.
So, we'll go with it anyway. Thanks.
All right. OR.
Thank you.
Judge, I have with me Mr. Henderson, call number 85.
This is case number B25041, Caitlin DeMonte Henderson. You've been indicted with 1 count notice of residence address change. Have you received a copy of your indictment?
He has.
How do you plead?
Enter plead not guilty on his behalf, as that Amy Dennis be appointed to represent him, Josh Hitch, for bond.
Where is he gonna stay?
Judge, as of right now, he is going to be staying at his regular home. However, as of right now, he has an APA holder, so regardless of bond, he is likely to be remaining in. So we're asking for a nominal bond in light of that holder, asking for 1,000 at 10%.
1,000 at 10%.
oh, wait, we need to do this on the record, Kathy. Yes. Number 92 on the record. Mr. Lewis asks us to continue that to tomorrow.
Okay.
You have the extradition paperwork.
Who's up first?
Judge, I have with me Mr. Hammond off of the extradition.
M2500644. It appears that you, Mr. Hammond, you're wanted in Florida. Is that correct?
Yeah, that's what I learned.
And you're going to voluntarily agree to go back to Florida and handle that case?
You said, you might say it one more time?
You're voluntarily agreeing to be extradited back to Florida to handle that
Yes,
case?
sir, yeah, yes, sir, I signed away.
All right, you signed the waiver? All right, I'm going to order that our sheriff release you to Broward County, Florida. You have any questions?
Yeah, I do have one. How do I have an attorney in Florida that I have his phone number, but is there any type of free call or anything to my attorney, or how does that work?
I don't know anything about your rights over there. What the sheriff does is that's her lane. I stay in my lane over here. So ask those individuals over there to determine whether or not you have a free phone call.
And how many days do they have?
We have 10 business days.
10 business days.
Does it start today, or when I got
As soon as I sign this document.
Oh, perfect, yeah, sign it quick. Thank you, Your Honor, I appreciate it.
All right.
But what I asked about the phone?
Judge, this is Daniel Langdon.
M2500645. Mr. Langdon, you are wanted in Kenton County, Kentucky. Is that your understanding?
Yes, sir.
And it appears that you have signed a waiver and you want to agree to be extradited back to Kenton County.
Yes, sir.
You look happy to go back to Kenton County.
I'm just ready to go.
All right, I'm gonna sign the order. You have any questions?
No,
All right, good luck to you.
thank you.
Judge, I have with me D'Angelo Walker.
M2500646. Mr. Walker, it appears that you are also wanted in Kenton County, Kentucky.
You said Campbell?
Kenton.
Okay, yes.
Yeah.
Yes, sir. Yes,
All
sir.
right, and you are agreeing to be extradited back to Kenton County?
Yes, sir.
All right, do you have any questions?
No, Your Honor.
All right, I will sign the order and they will transport you back to Kenton County. Good luck to you.
Thank you, Your Honor.
That's it? Okay.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
There's 4 ARs on the desk.
Is that it?
Everybody looks like they're wrapping it up, so.
We should be complete.